parents right across the country trying to figure out what to do with their children, how to keep them busy, learning and entertained. Now, that many are stuck inside during the COVID-19 pandemic, of course, but for those who are separated or divorced, it poses an additional challenge: how to share custody of the kids. There are certain things to keep in mind. Tanya Davies from Davies Law Firm joining us. Good morning. Good to see you. Thank you for your time.
Good morning, Leslie.
Okay, first question. Given the circumstances, what do we need to know? Has anything changed?
Oh, absolutely. Every level of society is obviously affected, Leslie, by the COVID-19 pandemic, and courts are no exception. The regular operations of the Superior Court of Justice have been suspended. However, what the public and our clients need to know is that courts are still open, and we have a triage judge who looks at the severity of the case and if it's an urgent issue. And courts are still open to deal with urgent situations through counsel. A lot of cases that we're seeing now in court that would qualify as an emergency situation would be in-person access suspension, where a primary resident parent is trying to suspend in-person access to the access parent that is normally in place due to the COVID-19 pandemic. And now we're getting some guidance from the courts. Just 2 days ago, a decision was released in the Hamilton court that gives us a legal test as to what qualifies as an emergency. So the court stated that a blanket policy that children should stay at home without seeing the access parent just because of the pandemic is not acceptable. It's not in the best interest of the child. So clearly, at this time of turmoil, we need to make sure that we practice safety measures. But children need more than ever guidance and emotional support from both parents. But there is a test where, in some circumstances, access should and will be suspended. There is zero tolerance for parents who are putting their children at risk to be exposed to the COVID-19 virus. So the test would be to qualify as an emergency if the access parent is unwilling or unable to practice safety measures that are being imposed by public health, by the government. So let's say if they're not willing to practice social distancing, are not disinfecting, are more at risk and exposure for illnesses because of their work situation, for example. They're traveling a lot for work. In those situations, access absolutely shall be suspended. Children come first.
Okay, that's good to know. The second one is probably much more common, and that is you have one parent, even if under amicable circumstances, you may say, let me keep the kids until this is over. Can you say that? And if not, what advice do you give the parent who has been told to stay away from the kids in the short term?
Again, only in circumstances where this would qualify as an emergency, and without even proceeding to court, parents need to know that this is your basic guideline. If the access parent is not at risk or high risk of exposure, they're healthy, they're willing to exercise proper safety measures that are being imposed due to COVID-19, access should take place. I'm not going to say, as usual, you would not go to a public place, for example. The access parent would stay at home with the child, but access should not be suspended unless there is a risk of exposure to the child.
And if one of the parents is unwilling, that's when you call the lawyer?
Correct.
Okay, perfect. I think we got it covered. Tanya Davies, appreciate your expertise on this. Thank you.
Thanks very much, Leslie.